This is passage number 6, duration 6 minutes, speed 100 words per minute. Dictation starts now. The petitioners have approached this court under Article 226 of the Constitution of India, seeking a writ of certiorari to quash and set aside the notice issued by the municipal corporation under Section 351 of the Mumbai Municipal Corporation Act. The impugned notice directs the petitioners to remove the alleged unauthorized extension carried out on the fourth floor of the subject building. It is the case of the petitioners that the said construction was carried out after obtaining due permission from the planning authority in the year 1998. They contend that the corporation has issued the notice without considering the sanctioned plans and the occupation certificate already granted to the building. Para. The learned counsel appearing for the petitioners submitted that the action of the corporation is high-handed and violates the mandatory procedure prescribed under the law. He argued that no prior show cause notice was served upon the petitioners, thereby denying them an opportunity to explain the legality of the structure. It is further submitted that the building has been in existence for more than 25 years and suddenly corporation has categorized a portion of it as illegal at the behest of a disgruntled neighbor who has a personal grudge against the petitioners. The council prayed for an ad interim stay on the demolition activity till the final disposal of this petition. Para. On the other hand, the learned counsel representing the municipal corporation produced the original records and the site inspection report. He pointed out that during the recent survey, it was found that the petitioners had enclosed the open terrace area and converted it into a habitable room without any revised permission. He argued that such an authorized conversion puts additional load on the structure and poses a threat to the safety of other occupants. The corporation maintains that the notice is perfectly legal and the petitioners have failed to produce any document to prove that the terrace enclosure was part of the original sanctioned plan. It was urged that this court should not exercise its extraordinary jurisdiction to protect a rank trespasser or an illegal builder. Para. We have heard that submissions and perused the photographs placed on record. It is a well settled principle that while the corporation has the power to remove illegal constructions, such power must be exercised in a fair and transparent manner. If a structure has been in existence for a long period, the authorities are expected to verify the historical records before taking any drastic steps like demolition. However, at the same time, this code cannot remain a silent spectator to the rampant unauthorized constructions that are mushrooming in the city in blatant violation of the building bylaws. The balance must be struck between the individual right to property and the public interest involved in planned urban development. Para. In the present case, we find that there is a genuine dispute regarding the authenticity of the revised plans produced by the petitioners. In such a situation, it would be appropriate to direct the municipal commissioner or a senior officer designated by him to grant a personal hearing to the petitioners. The petitioner shall be at liberty to produce all the original documents and maps in support of their claim. The officer shall then pass a reasoned order after considering the representation. Until such a decision is taken and communicated to the petitioners, no coercive action shall be taken by the corporation in respect of the suit premises. We make it clear that we have not expressed any opinion on the merits of the case. Para. The petitioner is accordingly disposed of. With the above direction, all the contentions of the both parties are kept open. No order as to cost. The interim relief granted earlier shall continue for a period of 2 weeks. Over. Stop.